Big breaking news. Supreme Court of India had stayed Sedition Law, which comes under Indian Penal Code section 124A. The most important, the most draconian, the most negative, the most bad law in the independent India is section 124A. Personally, I also rejected this section 124A. So why the Supreme Court had ordered a stay on this section 124A? That I am going to discuss. When N.V. Ramana became the Chief Justice of India, from the day one onwards, he was reforming the judicial system, and in the 2021 also he told that the law which arrested Mahatma Gandhi, Bal Gangadhar Tilak, when they are fighting genuinely for the freedom of India, the British has arrested them. That on the basis of the Sedition Act of section 124A, why we are continuing with such law? Whether there is any place in this independent India for this seditious act? The most debated, the most argued section of independent India in the Indian Penal Code is section 124A. That I am going to discuss today. Why? Because the Supreme Court imposed a stay on seditious law, which arrested a lot of genuine people, which arrested a lot of democratic rights people, where the people who criticized the government were being arrested on the method of disturbing the order of the state, disturbing of the order of the society. On that basis, they were being arrested. So it's obviously, it's a good thing for the people who support the democracy, for the people who supports the liberal views. This is 100% a very good view, a very good thing which happened by the Supreme Court of India. That is what I am going to discuss now. So Seditious Act comes under section 124A of Indian Penal Code. It defines any activity, any newspaper article, any vocal expression, any speaker, because of his speech, because of his or her expression, if there is any disturbance to the order of the state, then that particular person will be tried under Seditious Act. What happened? The government has been interpreted in many ways. Who criticizes the government, who questions the government, who demands the justice from the government were being booked under Seditious Act. So the thought process of British, when they had started the Seditious Act of section 124A in 1870, was to stop all the anti-government activities, all anti-British India activities in British times. We continued in the independent India also. So from the day one of 1947, August 16th onwards, first day of independent India, this particular section was being debated. So there is some significance, there is some positive also, there is some advantage of this section 124A. Number one, reasonable restriction. So if I am, whatever I want, if I speak, whatever I want to do, if I do, what will happen? The order in the society will be disturbed. The state which is having a proper stable order will be disturbed, because of which the section 124 is keeping reasonable restrictions so that the people who are responsible in disturbing the order in the society will be restricted. So yes, it is advantageous for reasonable restriction. And maintaining unity and integrity. If some people come and tell that we want Khalistan, we want Dravidian Nadu, we want Greater Nagalim, so whether the government should keep quiet? No. In order to maintain the unity and integrity of the nation, yes, section 124A is useful. Maintaining stability of the state. If anyone acts against the wish of the state, if anyone is disturbing the law and order in the country, in order to have the stability, compulsory section 124A is helpful. These are all the significance, these are all the advantages of section 124A. But however, there are issues, there are disadvantages, there are negatives. Number one, relic of colonial mindset, relic of colonial era. So in colonial mindset, when this particular act was being made in 1870, you are continuing in the independent India also. That means the same colonial laws, the same colonial mindset is moving in the independent India also. In the independent India, there is no space for colonial mindset, colonial laws like section 124A. Second, Constituent Assembly, which is responsible for the making of the Constitution of India, they were uniformly criticized the seditious law. They told that the seditious law should not be in the Constitution in any cost. There should not be any law also on the sedition. So, in order to support in letter and spirit the Constituent Assembly, we have to go against the seditious law. And the most important, Supreme Court of India already in the judgment of Kedarnath Singh versus State of Bihar. Kedarnath versus State of Bihar, the Supreme Court very clearly told that the seditious law should be used very reasonably, very restrictedly. For every action against the government, for every criticism against the government should not be booked under Seditious Act. So, because of this negatives, yes, we as a whole society were been demanding for removal of the Seditious Act of 124. Finally, repression. It's a repression of democratic values. It is a repression of democratic values. I am the person who believes in democracy. I am the person who believes in liberalism. So, it is a repression on the democratic values of the society. Because of this negatives, yes, Section 124A should be removed. And thanks to the Supreme Court of India, finally in 2022 understood that yes, there is a need for stay on the Seditious Act. There is a need to act against the draconian law of independent India, which is Section 124A. By this, I am finishing off the lecture on Section 124A. Like the video if you like it, share it and subscribe to our channel. Thank you. All the best. Jai Hind.